Welcome to this in-depth explainer. Today, we're going to completely dissect the massive implications of the August 2026 Bombay High Court ruling on IGST, that's the Integrated Goods and Services Tax, specifically for ocean freight. If you operate anywhere in the shipping or freight forwarding space, you already know the regulatory landscape can feel a bit like walking through a minefield. So we're taking a highly structured, deep dive into a recent legal decision that has the whole industry talking, and we're going to decode exactly what it means for your bottom line.
Picture this. Your finance team opens a GST notice demanding literally crores for freight charged 3 whole years ago. You're probably staring at that paperwork thinking, wait a minute, didn't we already settle this ocean freight tax fight back in 2022? You really thought this battle was in the rearview mirror, right? But, well, the reality of tax law is rarely that clean, and the legacy of old rules has a funny way of haunting businesses years after the fact.
So let's actually dive into this brand new development, which was just reported by EY India a few days ago on August 18th, 2026. Basically, the Bombay High Court quashed a massive legacy tax demand, ruling that Indian shipping companies absolutely do not owe IGST on ocean freight charged to foreign exporters. Now, a lot of the headlines are framing this as the final nail in the coffin for the ocean freight tax. But as we're about to see, mainstream coverage is really oversimplifying a highly technical situation.
To figure out if this ruling actually protects your business, here is how we're going to methodically unpack this today. We'll look at the demand notice shock, the mechanics of double taxation, the Supreme Court precedent, the crucial 2026 High Court nuance, and finally, your legacy exposure versus future rules.
Starting right off with Part 1, the demand notice shock.
This is the immediate pain point hitting shipping companies today. Tax authorities are targeting Indian shipping lines with demands for crores in GST, specifically for freight income earned back in financial year 2021 to 2022. The core issue? IGST being levied on freight charged to foreign exporters. And the root cause of this massive headache is Section 13(9) of the IGST Act. Before it was omitted, this section basically fixed the place of supply for freight transport services as the destination of the goods, which of course is India. So it aggressively pulled freight income right into India's tax net, even when both the supplier and the recipient of the service were completely foreign entities sitting outside the country.
Which brings us to Part 2, mechanics of double taxation.
To really grasp why this specific tax enforcement is such a mess, we need to look at the anatomy of a real-world transaction. Walk through these steps with me. Step 1. A European seller ships machinery to an Indian buyer on CIF terms, meaning cost, insurance, and freight are all bundled into one single price. Step 2. Indian Customs calculates duty on that full bundled value, which naturally already includes the freight the seller paid to the shipping line. But then Step 3 happens. The tax department comes along and demands IGST separately from the shipping line on that exact same freight. The result? You guessed it. The exact same rupee is getting taxed twice, once through customs duty at the border and a second time through GST.
And that brings in the ultimate shield, the legal doctrine of composite supply, which is defined under Section 8 of the CGST Act. This principle explicitly states that a bundled supply of goods and services has to be taxed once as a whole. You cannot artificially break it into separate taxable parts. It logically prevents the government from taxing the goods at customs based on their total value, and then trying to carve out just the freight service to tax it all over again.
All right, moving to Part 3, the Supreme Court precedent.
This glaring double taxation problem was heavily litigated for years, leading up to a monumental 2022 legal decision. The Supreme Court ruled in the landmark case of Union of India v. Mohit Minerals, and they affirmed exactly what we just broke down. Carving out ocean freight for separate IGST when it's already part of a CIF import entirely violates the composite supply principle. The court officially declared that taxing this freight separately is, without a doubt, double taxation. It was a massive victory. But, as anyone dealing with tax law knows, a victory for one specific scenario doesn't automatically cover everything else.
Now check out this timeline, because this is where things get super confusing. In 2022, the Supreme Court ruled in Mohit Minerals. Following that logic, on October 1st, 2023, Parliament actually fixed the underlying law by omitting Section 13(9) of the IGST Act entirely. The law was officially changed. Yet, here we are in August 2026, and the Bombay High Court is ruling on a new dispute. Why? Because those legacy demands for income earned before that October 2023 cutoff are still actively hitting businesses today.
Let's dig into Part 4, the 2026 High Court nuance.
This is exactly why the mainstream headlines saying the ocean freight tax is scrapped again are completely missing the point. As EY India flagged in their August 18th tax alert, the new 2026 Bombay High Court ruling deals with a materially different fact pattern from the 2022 case. See, the 2022 Mohit Minerals ruling protected the importer from paying IGST under the reverse charge mechanism. But this new 2026 Bombay High Court ruling protects the carrier directly from paying IGST on their freight income. The court essentially took that Mohit Minerals double taxation logic and extended it to a completely new target. This is a huge shift for Indian shipping lines who are being directly targeted for their old freight income.
Finally, Part 5, Legacy Exposure versus Future Rules.
So what's your actual operational playbook here? Let's apply this in-depth legal understanding to your live disputes. If your shipping company is holding a dispute or a refund claim for freight income earned before October 1, 2023, this new 2026 Bombay High Court ruling is your specific shield. You cite this directly because it perfectly matches the scenario of a carrier being taxed. But if your operations and disputes are for anything after October 1, 2023, you don't even need to reach for this court case. For future operations, you just rely directly on Parliament's statutory omission of Section 13(9). The law was already fixed for you.
We've explored the legal depths of this journey, and hopefully, this emphasizes exactly why understanding the specific timeline and target of your tax dispute is absolutely crucial. The bottom line is pretty clear. This 2026 ruling settles old, legacy freight tax fights under the now omitted rules. It doesn't dictate new ones. Knowing exactly which fight your finance team is having determines which legal weapon you pull from your arsenal.
I'm going to leave you with a pretty provocative thought to explore with your tax advisors. If your company quietly paid that IGST on pre-October 2023 freight just to make the headache go away, and you never actually appealed, does this new 2026 ruling open a window for a massive, fresh refund claim today? Or has the limitation period completely run out? Untangling the timeline of these legacy refunds is exactly why we dive so deep into the mechanics of these rulings. Thank you for joining me for this explainer, and keep asking the right questions about your data and your operations.